so much for everyone joining us today. We're very excited to be doing our first Meet the Candidates event. This event is sponsored by National Parents Organization and National Parents Organization of Florida. And we are very proud to introduce to you Mikaela Nix. Mikaela, would you like to say hi?
Hello, everybody, and thank you for watching. And most importantly, thank you, National Parenting Organization, for having this formal candidates forum. I think it's very important. So thank you very much. And thank you for having me to the panel.
Great, thank you. Next, I'd like to introduce our expert panelists. Joining us today is Don Hubin. Hi, Don.
Hello.
Next, we have Leanna Micah. Hi, Leanna.
Hey.
And next, we have Chris Batcheller.
Howdy.
And we have lawyer Leslie. How you doing,
Hi.
And next we have Kene, Anusionwu. I think you're on mute, Kene.
All right. Sorry, how's everyone doing?
Doing good. And next we have Melissa Isaak. Hi, Melissa.
Hey.
First, let me introduce Don Hubin. He's the chair of National Parents Organization. He's going to give us a brief background on what NPO is and what we do in our mission.
I am going to be very brief, and I'm going to apologize to Mikaela. I'm going to have to leave at about 7:30 or so for another commitment that I have. National Parents Organization is a 501c3 organization focused on promoting children's well-being by ensuring that they have the love and care of both their parents, even when the parents live apart. We promote equal shared parenting because the research shows that this is what's in the best interest of children. Increasingly, what we're learning is that the ill effects of parental separation are not really caused by parental separation, but by parental deprivation. And so we're working to ensure that the children have the active day-to-day care and involvement of both the parents when the parents separate. We have affiliates in about 25 states. Is that correct, Leanna? I'm maybe 26 now, I can't remember. We're working to really reform the norms about separated parenting, one part of which is to change state laws and court rules about shared parenting, but another part is to change parents' expectations about how they'll parent when they're no longer living together.
Great. Thank you very much, Don. Appreciate the background and what National Parents Organization is all about. Next, before we begin the question and ask session of the Meet the Candidate, I want to do the Pledge of Allegiance. We should have a flag that comes up there, and we're going to do a quick Pledge of Allegiance here. If everyone could just stick your hand over your heart and recite after me or with me. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, liberty and justice for all. Great, thank you so much. Next, I'm going to introduce Chris Batcheller. Chris is going to be the moderator and kick us off with the question and answer session. And before we get to that, Mikaela, I did take a look at some of the stats here in Orange County as far as the Orange County Supervisor election. This was accurate as of 12/24 today. But out of the registered voters, there's been about 13.35% that have voted, and we have another 86.65% that have not voted. So, with any further ado, let me introduce Chris Batcheller. Chris?
Well, welcome everybody, and thanks for joining us tonight. We have a star-studded panel here.
of Advocates for Shared Parenting. And we have some questions for Judge Mikaela Nix, and she's running for judge in the Ninth Circuit District of Florida. And so we have a great cast here today. I think we're going to have lots of good questions, and I'm really looking forward to this conversation. So with that, we'll get it started. And can you tell us, Ms. Nix, why you're an attorney in Florida, and why are you running for judge, and what's important for you and your platform?
Sure. So my name is Mikaela Nix, and I am running to be your next Ninth Circuit judge, which encompasses Orange and Osceola County for Group 1. I am a wife, a mother of a small child named Dylan. He is 3 years old. And I have experience and really some prominent background. So my family's been here since 1887 in the Central Florida Rochelle community. I've been in the Orlando community of Orange County for about 20 years. I went to the University of Central Florida, go Knights. I went to the Florida A&M College of Law. You're a rattler up there. And then I pursued my legal career as a solo practitioner. I've been in the family law arena primarily as a solo practitioner, but I have completed over 75 bench trials, was a former certified mediator. With that, I've done my own mediations. I have done pretty much, when you're talking about family law, it's a very broad area. So I have been able to do cases in every single area in the Ninth Circuit, meaning I have done domestic violence, and that's criminal and civil. I've done mental health, probate, juvenile dependency, juvenile termination of parental rights. And those things, civil cases, misdemeanors and felony when we're talking about criminal. Specifically, a family law arena encompasses a lot. And so when you're talking about a unique family environment, there are tons of things that can come with that. So as a family lawyer, I have always been a champion of all types of families. With that being said, I'm an advocate for the community. Not only do I have experience in these family law arena and the criminal law arena with bench and jury trials, I've also been dedicated to this community. And so when I say that I am in the community, I'm not just talking about being in the community, I'm actually walking that life. And I've done that for the last 20 years, whether that's being the University of Central Florida alumni president or speaking to the Orlando Juvenile Justice Detention Center students, kids. There's just a plethora of things that I've done. We'll talk about that some more. And then finally, just diversity. We really need diversity on our bench. And diversity doesn't just come with cultural competency. I believe that every judge, and I think the Ninth Circuit does a pretty good job of having judges who are fair, they don't, non-biased. But I do think that being an African-American woman of color adds a cherry on top. Does it change the law? Does it make the law differ in any way? But it does give a sense for some people of relatability. So that doesn't mean vote for me because I'm a woman of color. That means that I think that's an asset, an additive, or like I say, a cherry on top of the cupcake. And then finally, I think that your voice is your vote. So I'm very excited today to take some questions from this panel to maybe answer some of those said questions that people who haven't voted, or who really don't know me yet, get a chance to know me, and hopefully they decide to vote for me.
Well, fantastic. And so how long have you been an attorney? Can you give us a little bit of a background of, how did you get to becoming an attorney? What made you want to become an attorney?
Sure. So when I was in high school, I went to an art school, New York School of the Arts. And many people thought that I was going to go into the discipline of music. So I've played clarinet for my life. I've played piano since I was a small child. But when I went to the courtroom with my dad, who was very active in civic duty, he was a person that said, hey, you need to go to the courthouse. You need to learn about being a juror. And he took me to the courthouse, and I fell in love. I fell in love with the whole atmosphere. And my dad is the type of father that if he wanted to do something, he would try his best to make sure that we have those availabilities and those options. So we didn't know a lot of judges, but he found a judge for me, and it was Take Your Daughter to Work Day. I'm not really sure if we have those anymore, but Take Your Daughter to Work Day, and I was Judge Williams' daughter for the day. And I got to go behind the scenes in the chambers, and I remember telling my dad, I'm gonna be a lawyer, and then Daddy, I'm gonna be a judge. And my dad was always very strong and said, okay, that's what you wanna do. Just always remember that nobody is perfect and nobody wants to be judged by somebody who is. And so it was that point that I then went to the University of Central Florida. I majored in political science and history. And then I became a lawyer after that point of passing the Florida bar. being admitted to the United States Tax Court. Then I was talking about being a Florida Supreme Court mediator. And then finally, what made me really want to become a judge is when I was reading the 2019 article by Shannon Green in the Orlando Sentinel. And the article was titled, "Even in 2019, some Central Florida communities are seeing their first African-American judge." And that touched me in a lot of different ways. I work with families, my communities. And I said, wow, I don't really see the community reflected on the bench. And so I prayed on it, I fasted on it. And I said, all right, if this is what I'm going to do, I'm going to need all the help I can get. And it's just been an outcry of endorsement people. And I'm just very excited to even be endorsed by the Orlando Sentinel and others.
Well, that's a fantastic story. And can you tell us a little bit about your experience in the Ninth Circuit? You've obviously been practicing for a while. What's your experience, and from making that transition from an attorney to a judge? What are some of the things that you think you would do maybe a little bit differently from some of the current judges that would maybe bring some fairness to some of the families that are in the court system?
I think our Ninth Circuit Court judges do a good job. I do. I think that having cultural competency in people having different experiences is what is going to make me an asset or make me a little bit different. I have been well versed and well traveled. I have the ability to meet different types of people in the community. And so whether that's talking to senior citizens who may be grandparents and taking care of their grandchildren's children, even so, or whether that is young children who are now, or young fathers who are now having kids out of, are not getting married, and now they are looking at the Chapter 742 or the paternity statute, which sometimes does not necessarily give that father automatic rights like they would if they were married. And seeing those things, understanding that, being a millennial myself, understanding that everyone's not going to necessarily get married first. Some people are going to have children outside of wedlock, and that those are important issues that we talk about. And so I think that I bring just a plethora of different experiences. I think also sitting on boards are a huge plus. So in 2016, I was appointed to the Charter Review Commission for Orange County by our former mayor, Teresa Jacobs. And I got to go around Orange County and I got to really listen to folks. I got to listen to their concerns, and just being in those roles, the procedural roles, being the person at the Constitution Revisions Chair that was in a role of presiding over meetings. I've already done that, right? So I've already done some of the things that a judge would do, meaning being impartial, having the ability to listen, and not just listen at the case, listen to the people. And I think I do that very well. And I think that that is a strength that I will bring. I will bring some more cultural diversity. We have unique families. Every family is not the same. And I think that it's an opportunity to really look into those families and learn and have a background and understand that every family is not the same. And so when you're making those decisions and you're making those rulings, having what I call a tool bag of different types of tools that may be able to aid you it's a huge plus. And I bring a huge bag of tools.
And this question is for the other lawyers on the panel here. What is your experience with your local courts, and would you say that they are, bringing fairness to the system, and what have you seen in your daily work?
I'm a family law attorney in the Ninth Circuit, but I also handle family law cases all over the state of Florida. I've got about 90 cases right now, and they stretch all the way from the Panhandle to South Florida. I would say the biggest issue that I see is efficiency. And it really does come down to the judge because I handle so many different counties. I'm not just set with one county with one group of judges. I see some judges who are extremely efficient and they can get people hearings. And then I see judges who are not efficient at all. And you might not get a hearing in their courtroom for 6 months down the line. So it's a very big problem when parents are not getting contact with the other parent, with their child, efficiency and how judges are going to handle efficiency. So that's what I've seen in Florida.
Melissa, what have you seen?
I practice in Florida and Alabama, and I think that that's a common complaint actually here nationwide is people aren't getting hearings fast enough, or you might file for an emergency hearing or emergency matter and it's not heard. And then by the time it's heard, the issue has either, it rarely resolves itself, but it's hard to get kids back once they left the state. And so that's what happens a lot. And I will agree. I think most judges, in my experience, I think one of two things. I think they want to do the right thing. And I think that they don't want to be bothered with domestic relations cases. I think those are the two biggest things that I see with judges, is some of them don't even like them. And then they'll tell me, I don't want to deal with this case. I'm going to send you guys to mediation or whatever the case is. But the problem is I don't see fairness. I don't. I think I see some courts are very lopsided, and they're still very in favor of the mother. And, some judges will say, well, this is the way it's always been. This is the way we've always done things. So we need some fresh faces on the bench to say, I understand this way it's always been done, but that doesn't mean it's right. It doesn't mean it's okay. So, I think most judges have good intentions. I do believe that they do, even though I disagree with their rulings. The research has been around long enough that these judges can't claim ignorance anymore and shouldn't be able to say, well, this is the way it's always been done. When we have studies that have been out showing that shared parenting or, contact with both parents, minimum 35% of the time is what's best for children. So it's good to get people like Mikaela on the bench who have this research, and they're going to take it with them and say, I don't care what you've been doing the last 65 years. It's not working. And I think the statistics show that. So, this is not a judge bashing session by any means, but if we're going to address some problems that exist in the family court, we need to be real with what the problems are.
Absolutely. And Kene?
Yes, good evening. One of the biggest problems I encounter is lack of preparation. A lot of times the attorneys spend a lot of time preparing pre-trial memos, getting evidence prepared, meeting with the opposing counsel, doing everything that's required to make sure that they're prepared for trial or prepared for a hearing. And then you get to the hearing and the judge is just like, oh, so what's going on in this case?
Mm-hmm.
And that can be a problem because we want our judges to understand our case a little bit before we come in front of them. So it saves us time. And another problem, of course, that we have is hearing time. So if you have an hour to address temporary time sharing, establishment of child support, a plethora of issues, if the judge hasn't reviewed the file, hasn't looked at some of the prepared guidelines or evidence, we've already lost half an hour right there trying to get to understand those things. So those are issues. From when I first started practicing to now, the amount of time that we're allotted for issues has been cut by at least 50%, in my opinion. When I first started practicing, you could get a 3-hour slot for a temporary relief hearing. Now you're lucky if you get an hour. So if you got an hour and then a judge doesn't know what's going on in your case, that's a problem. And I understand the population is growing, but we just need to have judges that want to at least review the file prior to the hearings or trials. And, good thing about Attorney Nix, soon to be Judge Nix, potentially is that she has experience in family law.
Absolutely.
So, that will help. Even though family law is not the only area that we need help in, it's the area that we're interested in because that's what we practice in primarily.
Sure. So I'm going to phrase this question first for the attorneys, and then Mikaela, I'd like you to answer it. But the question is, so shared parenting, one of the things that I believe that it does is it streamlines some of these cases where it will remove conflict for some families, and thereby removing conflict means that you have less to do in court. And so what's your thoughts on that? And do you think that's a true statement that shared parenting reduces conflict and brings some streamlining to the family court process for most families?
Would you like me to start?
Sure, yeah, sorry.
Start. Oh, no, that's okay. I think that the reason you have problems is because of the power struggle between parents. So I think, if you have time sharing arrangements that put parents at a 50-50, I think that would reduce one parent believing they've, got superiority over the other parent because they have more time sharing. So that's one thing that can help alleviate the power struggle. But the next issue comes into play as enforcement issues. I predominantly deal with enforcement issues. A lot of my clients are enforcement. So they can have, I always say they fall into one of two categories. You can have a great parenting plan. You can have a 50-50 parenting plan, which I have many clients that do. But then they come to me and they're alienated from their kid because even with a 50-50 parenting plan, the other parent is refusing to honor that parenting plan. So I think it has to be in combination. You need to start, with equal grounds for the parents in a visitation schedule that's a 50-50. But we also need judges that have some teeth, that are willing to find these parents in contempt. I can't tell you how many hearings I've been to because judges have discretion as to whether or not they want to find someone in contempt. They will just kind of give a warning. That doesn't work with these parents that are alienating the kids. So, there's got to be, the time sharing plan in place at a 50-50, and then there's got to be judges that have some teeth that want to actually, write orders and find parents in contempt who are not abiding by those orders when one parent decides not to abide by one. But that's where I see there's a dual relationship. You got to have the wording in the order, and then you have to have a judge who will be willing to enforce that order.
I think that's a common complaint that we're hearing nationally is that, people spend thousands and thousands of dollars getting these, parenting plans, these pieces of paper essentially from the court, and then the court will refuse to enforce them in any meaningful way. And so certainly that's a theme I think we've heard nationally over and over again. Melissa, what's your take on that?
I agree, and that complaint, that's a decades old complaint. I mean, that complaint has been in place long before I started practicing law, and it's something with family court. Family court is adversarial by nature. So by its very nature, it pits one parent against the other. So, even some of the judges will complain about how confrontational these cases get, and sometimes lawyers are in there and they're feeding the contention. But at the end of the day, that's the nature of the way that these are set up. They're not set up to be collaborative. I think we talk about collaborative law, we talk about collaborative mediation, but at the end of the day, all of us have had cases where there's other attorneys that you just know. When they're on the other side, you can predict exactly how this case is going to go. There's allegations made by these attorneys in almost every case that they have. So, and it's sad that when you think of how you're going to do your case, you look at who the judge is and who opposing counsel is, and you plan your case accordingly based upon, the judge and the opposing attorney. It has little to do with the law. And there's so much discretion. The judges have almost unfettered discretion. And it's very frustrating because if you're representing the father and he's having issue with contact with the children, you prove contempt, judge kind of shakes her finger and says, look, mom, you do that again, the court's going to come down on you after dad spends thousands of dollars to get into court to prove contempt. So there needs to be some consistency. We need to do away with this adversarial system altogether. It's not working. It has shown it hasn't worked. And I think we need to bring the Constitution into the family law courtrooms and give people their rights, enforce their rights, put mom and dad on equal footing, have a presumption of shared parenting. I think that's the constitutional thing to do. And I think some of these wrinkles will, iron themselves out.
So let me follow up that with a specific question. So if the court doesn't enforce these orders that they write, are they a real court? I mean, if they are there to protect you and make people follow these rules that they set up, and then you go to court and they don't follow these rules, then are they a real court? I mean, what's the purpose of the court then, right?
I would like to comment because I was actually researching extensively the law in this area, and the law on civil contempt gives judges discretion as to whether or not they want to enforce it. So that's the last little analysis. You can prove contempt, but then the judge has the discretion as to whether or not they want to enforce it. So the law, if you want change, you're gonna have to do statutory change because the law is what gives them the discretion. It's not such, so black and white in this area. It's the discretion that has been the problem, and that is written into the law.
Well, that is the problem. Discretion has been the problem again. Discretion has been the problem so long as family courts have been around. So, you know, you look at the criminal courts. Criminal courts had to go to sentencing guidelines because there was so much disparity in how people who committed similar crimes were being sentenced. You have one person who committed a crime and they got 6 months probation. You had another person who committed the same crime. They were given 10 years in prison, right? Using a hypothetical. So, but a family court is no different. It's no different. You can have a guy, a dad, and I say this because I represent fathers, but a father can go in, have a bunch of evidence, win his case, get his children, or get 50-50 of his children. You can have a dad with the exact same set of facts go in and lose everything. And that's just the nature of it. And when we go in with these shared parenting bills to try to get shared parenting, that's the biggest resistance we get is from the judges. They don't want to lose that discretion. They say, but every case is different. It requires discretion. The problem is if every case is different and if every case requires that specific attention, then why do we have these model parenting plans? Then why is it that if you lose in court, you get every other weekend? There's not a whole lot of discretion that goes into every other weekend and every Wednesday night. So that's been the biggest problem, is that discretion, because there's no real training for judges. Judges, you know, and it's great that Mikaela has some family law experience because a lot of them go on and they take the bench with no family law experience whatsoever, no real concept of these issues. So if we want to make things more fair, we need to tighten up the guidelines. We need to take away some of that discretion. And again, you know, we're dealing with fundamental constitutional rights, yet there's no scrutiny. There's no strict scrutiny that the state has to meet. There's no burden there to take rights away from parents. So, you know, there's a myriad of problems with family court, and it's important that we get people in who understand these problems so that when they take the bench and they make their rulings, they can rule accordingly.
Exactly, and I just wanted to, you know, the legislature hasn't done a great job in Florida, giving our judges, you know, a lot to work with when it comes to equal time sharing. You know, we got these 19, 20 factors, but what does that really do? You know, the judges weigh the factors however they want, and you can literally write in whatever you want under those factors. You can make those factors work however you want if you have a bias based on how you feel about the litigants or the case. You know, so these factors are very vague. They're not necessarily, in my opinion, very helpful for someone to prepare and say, okay, this is what I need to do to allow my client to get equal time sharing or get majority time sharing. So it definitely comes down to the legislature giving us some better things to work with. And anyone that's really studied the law on time sharing will probably agree with me. You know, it's too vague. It's too vague. Those factors are very wide open and give anybody an opportunity to just write whatever they feel is favorable to how they want to address the case. And then it's very hard to overturn that on appeal if a judge knows exactly what they want to write to get what they think is best based on their particular bias. So it does go back to the legislature doing a better job on the equal time sharing.
And Mikaela, we mentioned several times standard parenting plans. Can you tell us a little bit about what the parenting plans are in the Ninth Circuit? And, you know, what, you know, are, in your opinion, do they get used as is or do they get modified? And how good do you think they are?
Well, I think that the Ninth Circuit, we talked a lot, and I want to kind of just to go over just some of the, we've had a lot of.
Oh yeah, absolutely.
So the very first thing I want to say to Ms. Leslie, I would agree that a lot of times other lawyers, they can downplay family law attorneys. Meaning when they talk about bench trials, it's almost like, oh, that's just, you know, family lawyers aren't real,
yeah, I hear it.
right? Or like they don't research, or I mean, we just heard some amazing statistics and research from these lawyers. And so adversarially, as a family law attorney running for judge, it's very different than if you were a civil attorney running for a judge, or even a criminal attorney running for a judge, because we are in this courtroom every day with the same players. When you are in a criminal or civil world or a jury world, it's a new bite at the apple. You're getting new, fresh people to look at these fact-based situations. You're getting new, fresh ideas to look at the evidence and make decisions. And then the judge is there pretty much for procedural. They have some discretion, as we've indicated, but mostly you have some strict rules that you're going to be looking at. And family law, very different. It's very adversarial. And so a lot of times for us lawyers, you do look at who's that lawyer on the other side. And sometimes you can almost know pretty much how that person is going to structure their cases. Where in civil and sometimes criminal, they don't have that extra burden. They don't have the emotional factor of the case. And meaning with the other attorney, they're not going back and forth. When you're with the state attorney or you're with the civil case, you may have some mediations, of course, but you're not necessarily, I'll use the word attack, but you're not in there next to each other, going back and forth in the grit. I think family lawyers sometimes get the bottom of the stick handed to us because it's pro se in nature. Sometimes people can do this. And so they may not feel that the family law attorney is knowledgeable necessarily in all these other arenas. And so I just heard facts. I just heard research. And so I want to make sure that we are really understanding that bench trials are serious. Bench trials are important, and bench trials have discretion of judges to such a high degree, as we just heard from Attorney Kene. This is a, what I say is a very high emotional and very uneven sometimes playing field that the judges have. And sometimes the judges, they don't necessarily want to deal with some of these things. They may think that these issues that one or another family has may not be as meaningful. But that's where we have to get back to judges and their experiences. Because if you are experiencing someone in the African American community, maybe that hairdresser that they pay $100 to every month is important to that family. Maybe that Hispanic family who is going through a quinceañera and the father then gives money or the mother then gives money for that. That is important to that unique family situation. Or you may have a grandparent who has the children primarily. Or you may have a situation where mom or dad does not want to give that child back to another. You have enforcement issues. And so what I love about this forum is that I'm dealing with attorneys in family law, so they understand that bench trials are not as frivolous and unmeaningful as civil trials or as criminal trials. In fact, I believe that they are more important because you're dealing with the same judge every single day. Pardon me, you can be dealing with the same judge in every case. You have 4 or 5 of them. And every single time you're dealing with these judges on a high volume situation. I'm a solo practitioner. I have over hundreds of cases. And this is what happens. You're in the courtroom all the time. You're dealing with hearings and you're dealing with the same person that may have this bias, or they may have heard something before and now they use that same logic. They're not prepared to look at it freshly. Because when you're dealing with sometimes judges, you have a smart person. So they may think that their way is the right way. I think as a judge, I will be neutral. I am not the advocate in that courtroom. My job is to listen to the attorneys that have prepared these cases, to read their case law, to make decisions based on the attorneys and not to help an attorney or help a pro se person. I am there to merely run the courtroom and to make sure that the players are doing their jobs, and then I'm going to make a decision if I am elected based on the testimony that was heard that day, not on the testimony that I think, not on something that I've heard before. You have to have a family law attorney. I always say that they are extraordinary because they have to come in with not just emotional facts, because these are people's children. These are fundamental rights that we're dealing with. These are important issues, but we also have to have judges that start over every time. And that's what I have run into sometimes as an attorney, that they are still on the last hearing that we had or the last information they've had. They've already made up their mind before from hearing some set of evidentiary facts the last time. And so now we're here again because you're going to be there, right? Motion for temporary relief, enforcement issue, and now they've already made up their mind. I will not do that. I have a background in family law, and so I understand when they come to the courtroom how much they have prepared, how many hours have gone into that. And then second, as a solo practitioner, I understand that time is money. A lot of judges who come from maybe a different background, or they have others, maybe worked at a law firm, and they're not bringing in, some of the cases. They don't understand necessarily this is money. Every single time that we have to have these set hearings or come back, these are all billable hours, and so I think that that's important. As far as the shared parenting schedule, I have not seen anything really concrete in the Ninth Circuit. I'm going to be honest. It kind of changes with the judges. I think that's a fair assessment. I don't see anything kind of cut in stone. So that's my take on it. But as a judge, I follow the law, and so I'm glad that we're also talking about the three branches of government. A judge cannot make the law. And so that's where you're going to have to advocate that in the legislative branch. As a judge, I am to follow that law, and I am to look at the situation based on those facts that come into the courtroom on that day.
Leslie has a question.
Oh, yeah. So have you been able, because I'm big into efficiency, because I feel like that's such a problem in family court. Have you been able to speak to any judges about what their job duties are? And have you thought anything about any types of procedures and policies if you were to become judge that you would want to implement? For instance, like some judges expect case order or case law to be submitted within so many days. Some judges want CMCs right away. And also aside from just policies and procedures, if you've thought about what you might do as judge, what are your thoughts too on writing your own orders? Because I've recently come into issues with having to fight after the hearing on just how the order is going to be written. And a lot of judges get a little lazy about writing their own orders. But I know, we probably know the same judges in the Ninth Circuit, and there are some judges there that only want to write their own orders, and they're really prompt and efficient about that. So what are your views on that?
Great. So again, I think the benefit is that I'm a solo practitioner. I have to be efficient. I have over 90 something cases myself, Ms. Leslie, so I get it. I understand that time is money, and that as the lawyer in my office, I have to move my own cases along. I have to make sure that my clients are not having a backlog of hiring a lawyer for 1 month and then not seeing anything being done for the next 3 or 4 months. Nothing has happened in my case. So I'm really good about moving my own cases along in my current business as a lawyer and as a solo practitioner. And I will bring that same efficiency to the bench. What I do think is I like to write the orders. I think when we're talking about family law, that's another unique aspect that we have that one may not understand. The judges in family law, we're going to have multiple orders, and sometimes I have seen in my own cases that no one can get it right? The judge makes an order and one party is going to say something and they're going to say, well, that judge didn't mean that. And well, I think it's that way. And now, again, you may have a whole month go by before you actually have that order. And some people can use that to their benefit. Well, there's no order in place yet. I don't see an order, so I don't have anything to follow, right? Or it can't be a contempt because there was no order, right? And so when we talk about those things, I think that I would write my own orders. I think it's efficient. I think it's prompt. I think that the family law attorneys are looking for prompt decisions. This cannot just keep going on and on and on, because what ends up happening is that sometimes that lawyer could be affected. And a lot of times judges are they forget that their theory, that they don't understand practical application. So your client can't sit there for months and not have any resolution, because then they start looking at you, right? It's no longer that judge. Now it's, why haven't you, attorney, moved my case along? What are you doing? I'm paying you this amount of money and I have seen nothing, right? So I understand that way. And so I think that efficiency is very, very important. And I would write my own orders and I would have them out prompt. And I actually appreciate the judges in the Ninth Circuit that do that. There is no question anymore. I don't have to email it back to a person and they review it and email it back to that person. And then ultimately the judge says, both of you guys submit your own orders and I'll choose. I like to write my orders. I think that if I was chosen for this honorable position, that's exactly what I would do if I was put into the family law sector. And I would make sure that those got out on time so that we can move it along. Another thing that I think that I would do is to make sure that that mediation is in place and start case management conferences. Looking at the docket and not letting months go by, because sometimes attorneys do, I'm not gonna say they do that on purpose, but that could be a strategy for some attorneys, right? And so in the family law arena, especially in the Ninth Circuit, we have administrative rules. And so you may not be able to have a specific type of hearing until you have this type of mediation or something that way. So what I have seen is that months go by and 6, 7 months can go by, and then you're like, hey, what's happening? Why is there no mediation with nothing moving along? So I think that that is something that I would be huge about with CMCs. Case management conferences, why are these cases not moving along? Because ultimately it backlogs the docket. You have cases that are sitting on the docket from 2017, 2018, why? I believe that the judge should be able to take control of that procedurally and then have some CMCs or give out some notices and say, hey, if you don't move this case along in this amount of time of 10 months, then this case is going to get dismissed. So putting the fire under some of those attorneys. Hopefully that answers the question.
Mikaela, I have a question for you. So we know that the Supreme Court has said that the right to parent your child is a fundamental constitutional right. Right to parent being making decisions as far as education, medical, things of that nature. So in family court, there's no strict scrutiny. There's no burden that the state has to meet. We have this best interest standard, this amorphous best interest standard that is really very poorly defined. So as a judge sitting on the bench, how would you balance the two? How would you balance the best interest standard against the constitutional rights of parents?
So, I'm going to make decisions based on the individual basis. I think that family law is fact specific. And so I can't necessarily tell you how I'm going to rule on something because I don't have those facts in front of me, but I can say that those factors that we give, the lawyer's job is to make sure that the judge has the information in order to analyze those set of facts. And so sometimes I don't think that lawyers do a great job in helping the judge help them. So again, I think that is a fact by fact basis. And so I can say that my experiences in family law will obviously be helpful in that arena with the factors and going through those set factors. And I will be listening when I have those hearings for these specific things that should be discussed and said. And I will also look at the individual. I am all about the best interest of the child. And so that is important to me. And I am going to be listening for factors for this child. Not the two parents that may be arguing, not the two parents that don't like each other, but the child or the children that are involved in that case and making sure that their needs are met. Because the standard is best interest, but that standard is discretionary sometimes. And so I know that I will be, with my experience and my backgrounds, I will be able to look fully at that, of those set factors and making sure that the children ultimately have the best reasonable and meaningful contact that they can with their parents.
The next question I want to ask you revolves around conflict in family court. And, it's been mentioned several times that, on this session that, family court is adversarial. We've heard nationally that family courts are often, allegations are made that they're not proven true. And so, how would you be as a judge when lawyers bring false allegations to your courtroom? And how would you deal with those? The big complaint that we hear nationally is that false allegations get made, then they get proven false, and then there's no recourse for the accuser.
Well, I think that the family law statute gives, again, some deference, right? The willfulness, that's normally where people have the issue. Was that willful? Meaning, did that parent violate this order willfully or on purpose or anything?
I think the question specifically revolves around attorneys. So attorneys making false claims in court.
Well, those are ethical violations. And so if there's attorneys that are making false accusations that I know of, right? So as a judge, you're not going to be involved in all of the cases. So I'm not going to necessarily know unless it's brought to my attention if there's false allegations. So if something is brought to my attention by a lawyer, then I will definitely look at that. But I'm not going to necessarily advocate from the bench. I'm not going to help a lawyer or to help even a pro se person. That's not my job. That's not my role. My role is to make decisions, call balls and strikes. If I see something that's unethical or injustice, I'm going to call it out in my courtroom and I'm going to shut it down.
Okay. Let's see. Michael?
Hey, Mikaela, I have a question. Let's assume it's August 18th, you win the election. Advocates like myself that I know as a judge, you're not going to be able to. You gotta basically interpret the law and apply the law. You don't have the right to legislate. But as a nonprofit organization that has the empirical scientific research that proves that children's best lifetime outcomes come when they're in an equal share parenting arrangement, how accessible would the courts be with folks like myself that went in there to spread that message?
I don't know, Michael. I don't know how necessarily accessible they will be, but I do think that our chief judge is amazing as far as having an open door policy. He listens to people. He listens to the lawyers. I've been able to talk with many of the judges. If so, in the Ninth Circuit, they do normally have an open door policy. Some judges more than others. But I definitely think that they're open to listening to different organizations and to different people. I've had some very good feedback as far as
Okay,
judges listening.
thank you. And my other question, okay. Can you tell us, we're kind of switching gears here a little bit. Can you tell me a little bit about some of the community service that you have done in the Orlando area?
Definitely. So this is my exciting part. I think that judges should not just be at the top of this bench overlooking everyone, making these huge decisions about folks' lives, and we don't know any of them. Sometimes we don't even see them at events. They're just like hidden. I think they should be out and open. The courthouse is public. These are civil servants. This is an important role, and so I am in the community all the time. I host an annual Father's Appreciation event. This is my 7th year doing it, and that event has been just a blessing. And so it's not just fathers that come out. It's meaningful and reasonable contact with both parents. So I like to just make sure that I say that. It's not just one advocating for one over the other. I think that when you have a meaningful relationship with the children, with the parents, and any type of parents, it's always a benefit. So it's free. This event is free. They come out, fathers, they bring I pay for their fathers and their children and and loved ones. And it's not just fathers, it's father figures, because I don't always think that a father is necessarily cut in stone, right? We don't have cookie cutter families. People have very unique families. And so this event has been held for the last 7 years, and examples of them are at Grand Prix. The one I just did this year was at the Amway Arena for a celebrity basketball game with Floyd Mayweather, and we had over 700 dads and their kids come out, and they enjoyed food, and this is a great opportunity for the family to connect with mom, dad, kids, grandma, whoever wants to come out. We've done a plethora of different celebrities. We had Matt Morgan come out and talk to the kids, Pat Williams, Orlando Magic cheerleaders, just a plethora of different places. And I get so excited talking about it because it's my annual event, and I'm just so proud of the community, and they come out and they support it every year. I get little messages like, where is it going to be this year, right? Sometimes when I think they've forgotten, they don't. I give out college scholarships every year. I adopt a family every year for Christmas, and I do Thanksgiving baskets. I speak with the Juvenile Justice Detention Center. I'm a part of the Orlando Lutheran Towers as a former board member, which is a senior citizen facility for indigent seniors. I teach at former teacher at Valencia and Seminole State, where I've had great interactions with the young people. They inspire the generation. This upcoming generation is just amazing. Not only do I do that, like I said before, I am really, really big on making sure that kids also go to college. So I'm a part of the Law Explorers. I'm a committee member there, which is a part of the Boy Scouts, which if people want to be lawyers, the kids want to be lawyers from the age of 14 to 19, they come out and they learn about the process of law. We mentor them. We get to take them to the courtroom. We get to let them see the judges and meet the judges and all people in the legal world. And I've been doing that for about 3 or so years. I sponsor kids who can't afford and they want to come to make sure that they have opportunities. I'm probably missing out on some, but this is what I do. I am a community service person. I think you have to give back to your community. And I've been doing that for since I've been practicing. And even when I graduated from University of Central Florida, I was the alumni president there and did a lot of community service events. So community service is in my DNA. That's what I do. And I'm proud of it.
Excellent. Well, we're kind of running out of time here. Do we have any last questions from the panelists?
Yeah, I have a quick question. Attorney Nix, how did Florida A&M College of Law prepare you to be a lawyer, and how did it potentially prepare you to be a judge? You know, I want you to tell people a little bit about that law school, because this, even though it's in Orlando, I still feel like it's fairly unknown.
Great.
And it doesn't get enough publicity, in my opinion.
So the Florida A&M College of Law, I'm just going to give you a little bit of background. It didn't just open. It was closed down in 1954. So we originally had a college, FAMU College of Law, prior to the 50s, but when segregation came, unfortunately, in 1954, the school around there, the school closed down, and so it just reopened. So this is not a brand new law school. This is a law school that was coming back. So I want to make sure that we've said that. We've had Gwendolyn Cherry, who is an amazing lawyer, graduated from FAMU prior to it closing down. So FAMU has taught me a lot. Number one, it's taught me diversity. FAMU is an African-American, historically African-American school, but we've had a plethora of different types of people who come to our law school. It's amazing. Also, it's right in the community. And so you were able to do community service, you're able to have access. So FAMU has prepared me quite a bit. There's legal clinics there that I was involved in, the housing clinic, the clinic that I was involved in when I was in school. And so FAMU being a part of the community, having your courthouse down the street, having your federal courthouse right next to you, it's an advantage. FAMU had their own courtroom right inside their law school. It's very high-end. Military sometimes come in there. We've had lots of cases there. So having the ability to have a courtroom that's set up like some of on our second floor, they're actually set up like little courtrooms inside where the teachers are teaching. So we have an opportunity to have some great back and forth as far as questions and things of that nature for people who want to be litigants, but if litigation attorneys. But if you don't want to be a litigation attorney, we also have great avenues for transactional work. So FAMU and the FAMU professors have prepared me immensely. And so I'm proud of my school. I'm proud of the work that they do in the community. And more importantly, it's a state school. So it's a part of the whole system of Florida. And being state schools, the state of Florida should be very proud to have our state schools. And so I'm also very proud to be a FAMU alumni.
Before we wrap this up, Mikaela, just want to let you know that thank you so much for being our first candidate with National Parents Organization. You made history with us. So
thank you.
You will get a email from National Parents Organization asking how we did and asking how we improved, because we want to continue doing these forums and make the experience better. And we wanted to make you feel warm and welcome, but also bring some issues in light for the sake of our children and families in Orange and Osceola counties. Before we wrap it up, Chris, did you have any other questions?
I just wanted to see if Mikaela had any final thoughts that she'd like to leave us with before we wrap it up.
Sure.
Yeah, and on top of that, Mikaela, yeah, could you just let the voters of the Ninth Circuit Court in Orange and Osceola County why you might be their best judge?
Definitely. So first and foremost, thank you guys for having me. This is important. And like I said before, sometimes the family lawyers are kind of giving the shorter end of the stick. So I'm glad that we're talking about this. I'm glad that the viewers get to hear about bench trials. I'm glad that they get to hear about the difference between those bench trials and those civil trials. I'm glad that we hear that there are areas where they are mandatory guidelines versus in family law, where we have more of a discretion. So the judge is going to be very important in those specific roles. My name is Mikaela Nix, and I am running to be your next Ninth Circuit judge. I have experience over 75 bench trials. I run my own practice, and so I'm efficient. When I become, if I'm elected to become that final circuit judge, I will write some of my own orders, like we discussed before. But more importantly, I have fairness. I know how to talk to people with respect and dignity. And a lot of times, that's what people want. They want to be heard. They want a judge to not just shove them off and move on to the next case. They want to feel that they have gotten their time in court. They want to feel that their money, their lawyer, if they decided to do that, that is accurate, and they've got to have their time to be heard. And that's something that I believe in. That's something that I'm going to do. I'm going to allow the public to be back into the courtroom. I think you've seen and heard a lot about my community service experiences, and I'm very excited about that. I think that a judge is a civil servant, and if you don't have any community experience or you're not in the community, that this is just not the job for you. I have a vast amount of endorsements from the Orlando Sentinel to church leaders, lawyers, community people, and activists. I'm very proud about that too. You can go to my website, which is nix2020.com, and you can learn a lot about me from there. You can go to my Facebook, which is elect Mikaela Nix 2020, or Instagram or Twitter, which is elect Nix 2020, for some more information. Your voice is your vote. I suggest you guys please do your research. I think that you will find that out of the two candidates, I'm the candidate that was the most experienced in family law, most experience as far as the community arena, and I'm the only candidate that will be able to be placed in any of those said factors. I do believe that this is an important race. I do think that my opponent may have some biases in some of those other areas, as she recently has sued the Orlando Police Department. And so if we do have that person in family law, that person needs to know family law procedures. We are a different beast. And it's very important that people understand that. And so if I'm lucky enough to be placed in that